I hope that you can hear me at the back now. As I was mentioning, the session was scheduled to start at 9 o'clock, but there has been a slight delay because we're waiting for the audience, for the people to come. But I think we should start because I understand that a number of people have other commitments. I would like to welcome everyone in this room in the workshop on the public interest guidelines of the Commission. My name is Nelly Sakata. I'm from the Legal Services Division of the Competition Commission. On the panel we have Sima Nomko. She's the principal analyst from Merger and Acquisition Division. She is the project manager on this specific project, in fact. And together with her, we have my colleague from the Legal Services Division, Mr. Lane Quilliam. So, the purpose of the workshop today is really to have a conversation around the public interest guidelines that are in the draft form up to now. It's not in its final form, and we really thank every stakeholders who took the time to give their comments on the public interest. So we want to have that conversation around the issues that have been raised. We would like to have a constructive debate about some of the issues and possibly also try and clarify the Commission's position on certain of the issues, and of course have engaged on those issues. But of course, this workshop will not end to a situation where we will have finality, because the Commission still has to incorporate all the comments and the input that will have to be received. And from this workshop, there will be a final draft, but Sima will take you through the process. But really today, the purpose is to have that debate. It will not be a Q&A session where there will be questions from the audience and answers from the panel, because we're not in a position to answer all the questions, but we really want to have that engagement and have that constructive debate. So the format, as I mentioned, is going to be first a presentation by Sima. She will take you through the background of the draft of the guidelines to the public interest, the legislative framework, the general approach that the Commission intends following, and the line of inquiry into the assessment of public interest grounds. And my colleague Lane will take you through a summary of the public comments that we've received, the recurring aspects. And then from there, the floor will be open for debate, for engagements, for inputs, for discussion. So without any further ado, I will leave my colleague Sima to take you through the presentation. Thank you.
Good morning to all. I hope everyone can hear me clearly at the back. No. I hope that's better. Is that better? No.
I'm sitting from. Is it possible to move forward a bit? Because unfortunately the mic are not doing justice to our voice.
So I think we can start. I'm going to go through just a brief background on the guidelines, just an overview of what the objectives are, and then put on some other issues where we've had a lot of comments on the lines of inquiry.
This one is having just a problem. He has gone to collect something this week. He's having problems with it. So, yes.
So I'm gonna try and speak a bit louder, so hopefully those in the back can hear me. If not, please try and move forward until the problem is resolved. Okay, so just to take you through the background and the drafting of the guideline, I'm sure you are aware of some of the key cases that came up in the Commission's investigation, particularly the Walmart case and the Agri-Group merger, where there was a lot of conversation, a lot of debate around what the appropriate assessment standard should be in the public interest assessment. So those were just two of the cases that have created debate around how the Commission should assess the public interest issues in its merger assessment. I think those of us that work regularly in the field know that employment is obviously the most prominent public interest factor that comes up in most cases. The other factors are still largely undeveloped, so there's not a lot of case precedent on those issues. And then the Commission also faces a lot of challenge in terms of insufficient information, inadequate information, and this problem also arises because I think the Commission also doesn't always know what types of questions to ask up front, what kind of information is required to do the assessment, and similarly on the merging party side, we don't always get all the information that we think we need to do the assessment. Further on, the Commission has realized there's a need to clarify its approach to ensure that the purpose and objective of the Act is achieved. And we've also realized that there have been many useful lessons in the past 15 years in terms of case precedent, in terms of experience that we can draw from in order to contribute to the guideline. In terms of the objectives, the objectives to have a guideline is basically for the Commission to have guidance on the approach it's going to adopt, and also for the stakeholders that engage with the Commission on a regular basis to have the guidance on how the Commission is going to make that assessment. And also to have guidance on the types of information that we will require for the assessment, and to avoid unnecessary delays in the investigation that can arise from insufficient information, and that may result in delay in the investigation. We also want to create an environment of transparency and consistency so that each case is analyzed in the same way, and merging parties, when they file a transaction, they are aware of what the expectations are in terms of the public interest analysis. In terms of the process of drafting, the guideline was published for public comment in January 2015. The deadline for submission of comments was the 23rd of February. We thereafter extended the deadline to the 5th of March. And the deadline for publication is the 30th of September 2015, so that has been extended. Currently, we are in the process of assessing the comments received. We've gone through the comments. We are trying to determine how we include those in the draft guidelines, and trying to clarify some of those comments. So this is part of the process of clarification. We've also tried to engage counsel on some of the issues where we think we need further clarity on. So that's where we are. This is obviously not the final stage in the process. We still have some time to go through the process. So in terms of the legislative framework, the line of inquiry is set out in section 12A. So I'm not going to read through the entire section. It's in the Act. It just sets out the legislative framework for for the competition and the public interest inquiry. So a brief summary of the inquiry, and as also accepted in the CAC decision in the Walmart matter, was that Section 12A, one of the acts, sets out 3 lines of inquiry. First, we need to consider the competition, the effect on competition, and then we need to assess whether there are efficiency or competitive gains that arise. Obviously, that will follow from a finding of where there's a substantial lessening of competition. And then at the same time, we also need to consider whether there are any public interest considerations that will outweigh the negative competition effects identified. So notwithstanding the finding on the competition side and notwithstanding the finding on the efficiency assessment, we need to still consider whether the merger can or cannot be justified on public interest grounds. So I will explain further what that means. So in terms of the public interest line of inquiry that arises from Section 12A, 1 of the Act, suppose that there's a positive competition finding, the commission finds that there's a substantial negative public interest effect. Then the onus falls on the merging parties to justify the approval of the merger given the substantial negative effect. And suppose that there's a positive competition finding and the commission finds that there's a positive public interest effect, then no justification is required. So we just tried to maybe give more clarity on that because there was a lot of comments on the line of inquiry and on when parties need to justify and not justify the effects. So hopefully this helps to clarify some of those issues. And then in the second line of inquiry, where there's a negative competition finding, merging parties must justify the approval of the merger based on substantial public interest grounds. And suppose where there is a negative competition finding and the commission finds there's a substantial negative public interest effect, the commission will impose conditions or prohibit the merger. So I think it's just important to point out here that when it comes to the general framework and the use of the word justification, there's a difference in the context in which justification is used in the general framework and that which is used in terms of Section 12A1, the line of inquiry. So just to take you to the framework, this is a general framework proposed in the guideline. First, one is expected to determine the effect on the public interest by the merger, so whether it's a positive effect or a negative effect or a neutral effect. Then one is expected to determine whether that effect is merger specific. And then the next step is to determine whether it's a substantial effect or not a substantial effect, and then there's a justification required or a substantiation. I will explain in a while what we mean, and then remedies. So I think the best way to explain the general framework is to consider the line of inquiry as was explained earlier. So suppose that we find that there's a positive competition finding and a negative public interest effect. In that case, and we find that it's merger specific, in that case we'll have to determine whether the negative public interest effect is substantial. And suppose that we find that the negative effect is substantial, so it's merger specific and it's substantial, then the onus shifts to the merging parties to justify the substantial negative effect. And in that case, we're likely to consider remedies if we find that there's no proper justification for the substantial negative public interest effect. So that is a typical momentum scenario. Those of us that are familiar with momentum will see that it applies in that case. And then suppose we have a situation where we have a negative, we have a positive competition finding and a positive public interest effect. So in that case, there will not be a need to show that it's substantial or there's a need to justify a positive public interest effect. And then on the other line of inquiry, so where you have a negative competition finding and you have a negative public interest effect, in that case you will still have to show that it's substantial, and you will still have to justify the negative effect, because a merger could still be approved with conditions if there's proper justification for the negative effect, and remedies could be imposed rather than simply prohibiting the merger. And where there's a negative competition finding but a positive public interest effect, that's when merging parties will be required to show that the positive public interest effect is substantial, and and they expect to substantiate on the positive effect. So in that case, there's no justification required for the positive public interest effect. So you just have to substantiate and why the merger needs to be approved given the substantial positive effect. And in that case, there will also not be any remedies likely in that merger. Okay, I think that's it. We'll hand over to Lane.
Morning all. The general themes coming across from the comments that we received from the public began with the general concern on, even though that the guidelines are not binding on the Commission or any court, that in the Commission's implementation of these guidelines, they would act beyond the scope and their mandate in terms of the Act. The concerns related mainly to the industrial sector or region, where the analysis of the Commission would include the impact of the effect on the wider economy when taking into account certain factors. The going beyond the scope concern also included post-merger retrenchment requirements, or the analysis going beyond when the actual merger itself. Parties felt that this requirement, even though it included retrenchments that were not, may or may not be merger specific, felt that this was too onerous and went beyond the scope and requirements of the Act. It also extended to non-merger specific retrenchments before the implementation of the merger. This concern also said that even though it may or may not be merger specific, this requirement fell beyond the powers of the Commission. The second general theme coming across from the comments included a concern on the definition of merger specificity and how the Commission would deal with what is related to a merger. In the guidelines, it was noted that in certain instances, the Commission relied on a reasonable causal nexus. In other parts, the Commission indicated that it merely has to relate to a merger or flow from a merger, and it was suggested from the comments that a uniform definition of merger specificity would give greater clarity to this concept. Similarly, on what is substantial, the comments suggested that a uniform and global definition of what the Commission sees as substantial would give clarity to the steps within the guideline, giving factors that the Commission will take into account when determining what would be substantial under each public interest concern. Another general comment was the shifting of the so-called onus or the evidential burden on merging parties to show firstly that a merger is specific. This related to the potential retrenchments either before the merger or after the merger, as well as justifying the substantial effect. As Sima mentioned earlier, the concern didn't relate mainly to a situation where the competition assessment resulted in a non-substantial lessening of competition and a negative finding from the Commission on a public interest issue, thus requiring the parties to justify the negative public interest effect. It mainly related to the concern to justify as a separate step from the merging parties of justifying a positive public interest finding flowing from a negative competition assessment, or positive being a finding that would not substantially lessen competition. The concerns indicated that there would be no legal basis for the shifting of an evidential burden on the merging parties in relation to a positive finding on public interest effects. Another comment received was that in interpreting the guidelines, there is an undue focus on the negative effects on public interest, and it is not clear how the Commission will then assess positive or finding of the positive effects flowing from a negative or a finding of significant lessening of competition on the competition requirements. It was felt that in certain instances the meshing together of the factors would create certain confusion and should be separated for firstly a negative finding on competition or a positive finding on competition. Another concern raised where the guidelines mention a balancing of possible positive and negative effects on public interest or a balancing of a neutral effect on competition. This interpretation led to a concern of how the Commission would balance a finding on a neutral outcome between public interest effects and how this neutral effect would be balanced. Lastly, on the general comments, it was raised by a non-profit organization it was raised that should the guidelines or the actual factors taken into account by the Commission, should these factors specifically include or reference the provisions of Section 2 of the Constitution, mainly relating to a specific industrial sector or region, that when analyzing or determining the effect on a certain industrial region or sector, the nature of the sector or the product that is produced in that sector, if it is a constitutionally entrenched right to that product, should be taken as substantial, or should be taken as a significant factor in the Commission's analysis of that effect on that particular sector relating to a constitutionally entrenched service or product. More specifically on the industrial sector, we received comments on whether the Commission would view certain sectors in the economy as being more important in relation to public interest than other sectors. The concern here is that if the emerging parties had to guess or base it on indications on which sector would be important to the Commission, it may have a chilling effect where the emerging parties expect a negative effect on public interest flowing from emerging in that sector. However, to address this concern, the comments recommended that the Commission indicates the sectors that it would likely focus on during a merger assessment, and then the emerging parties who expect a negative result or a negative effect on public interest from the merger can then give further information to assist the Commission or then justify that negative effect within that focused sector or region. Another serious comment that came across quite strongly from the comments from the public is that an interpretation of the factors as well as the proposed remedies under the industrial sector or region portion of the guideline gave a strong indication that the Commission is anti-direct investment and that certain remedies had the potential to contravene the South Africa's international law obligations in relation to foreign firms. The Commission understands this concern to be based on the local treatment or the equal treatment between local firms and international firms derived from the obligations of international conventions. Further, in the analysis that the Commission undertake in terms of the guidelines was the factor on public policy, and it was suggested through the comments that such public policies from time to time should be clarified, and what these policies would entail and how the Commission would take these policies into account when determining the effect on such industrial sector or region. It was also raised that the Commission's analysis and focus on the supply agreements in this section of the industrial sector or region was unwarranted, because this was a private and commercial decision and should not be inhibited in any way by the Commission's analysis of a public interest effect on the industrial sector and should be left alone to the merging parties and their commercial decisions. On the weighty employment section, it was raised that the extensive information required by the Commission to comply with the analysis contemplated in terms of the guidelines is very onerous and would raise certain costs for merging parties. It was also raised as a concern that when the Commission requires information on contemplated retrenchment or initiated retrenchments in terms of the Labour Relations Act, either before the contemplated merger or after the merger, would place merging parties in a very difficult situation where if they haven't contemplated mergers but have to inform the Commission of the likelihood of such retrenchments coming about, they may contravene Section 189 of the Labour Relations Act, that requires them to start consulting with unions once retrenchments are contemplated. The comments suggested also that if merging parties are forced to come together and discuss the possibility or likelihood of retrenchments either before or after, mainly after the contemplated merger, that it may result in inappropriate information sharing or may even, in the extreme, result in prior implementation of the merger where those retrenchments are as a result or likely result of the merger after the implementation of the merger. One of the concerns also based on the time period within which the merging parties must indicate their retrenchments. I understand from the guidelines that it is a year after the intended merger, and when it is before the merger, the Commission requires information on all contemplated or initiated retrenchments from the date of the negotiation or the contemplation of the merger itself. The concern raised here is even with that guidance on the period, it was still unclear on how far back merging parties must go to notify the Commission of these retrenchments. It was also raised through the comments that taking in entirety the guidelines seek certain predetermined outcomes that go beyond the scope of the Act and seek to remedy high unemployment levels in the economy over and above what is required of them in terms of the public interest requirements in Section 12A. Moving to small medium enterprises and the ability to be competitive in international markets, the factors given in the SMME section, especially relating to what is substantial, the Commission and the guidelines set out certain factors that would be taken into account of what is substantial, but then at the end it referenced that any according to the comments, any raising of barriers to entry, any restriction on these SMMEs would be considered as substantial. And the comments raised the concern that even a very small, and even an indirect lessening of barriers to entry resulting from the merger may be seen as substantial, which the comments considered as unreasonable. The international competitive section was raised that the guidelines do not develop it any further and requires more clarity on what the Commission would consider as relevant efficiencies in the local economy as a national champion seeks to increase their exposure to international markets. Essentially, as stated in the background note and the guideline itself, the guideline seeks to give greater clarity and present the merging parties with the framework or methodology on how the Commission will analyze the factors under these public interest concerns, because we only have case law on certain very narrow issues, and the Commission felt that it would assist the emerging parties to provide the correct information to the correct point of what the Commission seeks to analyse in this general methodology. Taking that into account, even though it is general and non-binding, all these cases will be dealt with on a case-by-case basis on the facts presented to the Commission. These guidelines will, as mentioned, will be subject to the amendments flowing from the comments received as well as the discussion today, in an attempt to hopefully increase the transparency and consistency through the Commission's assessments, together with emerging parties and the information received from emerging parties. With the correct information, with greater transparency and what the Commission is looking for, we seek, or the guidelines seek, to avoid unnecessary and protracted delays in the Commission's assessment of these type of approaches.
All right. On this note, we now opening the floor for debate. As I mentioned earlier, that it's really to have a conversation around the issues that have been raised through the public comments, to have clarity on some of the issues, and to also have possibly clarity on the Commission's position. So the floor is now, the debate is now open. I'm not too sure if we have a wireless mic, if it's working. So if you can just bear with us. Okay, so I think to be a little bit, so that we're not too stressed, I'm going to go around. As I mentioned, it's really a debate now. It's open for conversation. So I don't know if there's some issues, yeah?
Hi, I don't know if you can answer this question now.
I'd like to ask everyone to introduce themselves and which company and then.
Hi, I'm Mumtaz Mullah and I'm representing the Property Owners Association. I don't know if you have an answer for me right now, but when you're looking at public interest, would you as the Commission be applying your mind to the declining economy, loss of jobs and that kind of thing when you're assessing public interest? You're looking at it.
The Commission will definitely look at that if it's something that relates to the merger before it. So in other words, the effect that the effect on the declining industry or the effect on a particular industry must be something that the merger brings about, and that is as far as the Commission can go in terms of assessing the effect in relation to a merger. So if there's a general industry concern, for example, the Commission doesn't have mandate to just investigate what the issues are in an industry unless it's the merger that causes that effect.
And the definition of substantial, would they be looking at it broad or narrowly?
The guidelines try to give an indication of what substantial will be on a case-by-case basis and then applicable to each particular public interest ground. So there's no set definition. You will see, for example, in the employment section, there's a number of factors that one would need to take into consideration in determining whether the effect is substantial. For example, the skill level of employees, where there's there's retrenchments of largely unskilled employees, for example, that may lead to a conclusion that it is a substantial effect because the view is that unskilled employees or semi-skilled employees are less prone to find alternative employment in a short space of time, and therefore the effect on them is likely to be substantial compared to skilled employees, for example, or management employees, for example.
And you have a definition for skilled and unskilled, a very specific definition for skilled and unskilled.
We don't have a set definition. Again, it varies from industry to industry. So we thought it not necessary to stick to a particular definition. What we try to focus on is rather to look at management employees, because I think generally across the industries, management employees will be those that are fairly skilled or have higher salary ranges than those that are semi-skilled or unskilled. So the focus will tend to be more on that issue rather than to define a skill.
Any other comments or?
Thank you. Leslie Morford from Weber Wenzel. So I understand from the presentation that you've taken these comments on board, but not really giving an indication on where you are in whether you think they're a good idea or not. Is that where you are? You're still considering them?
Thanks, Leslie. I think you would know from the presentation some of those comments have already been taken into account. For example, on the lines of inquiry, we've taken into account where there were comments on whether positive public interest effects need to be justified. So we've noted those. There is definitely a lot of comments that the Commission can accept and can rectify the guidelines on that basis. But as I said, there are issues that we thought we need to seek clarity on before we accept them, and we are engaging with Council on that issue. The Commission is still also looking through the guideline to see where there are loopholes, where there's ambiguity and things like that. So we have definitely considered the comments put before us. I don't think we're in a stage where we can say we've accepted all of them. I think in the next few months we'll still go through that process.
So just a quick follow-on question, just to understand, as you say, it's only going to come out in September. Is there going to be another opportunity to comment on another draft that comes out, or what is your thinking?
I think we haven't obviously factored that into the plan at the moment, but I think we do have time set aside that we could send or at least get the view of practitioners on the issue or on the revised guideline before we finally adopt it. So we do have time set aside for that.
Sher Mohammed Khan from Section 27. You mentioned in your previous answer that you were seeking clarity on a few issues. Would that be seeking clarity from one council, from within your own ranks, as well as stakeholders? Could we have more clarity on that?
Yeah, in fact, we're seeking clarity from also our stakeholders who are present. So as you're representing Section 27, we're very happy that you're here so you can clarify on certain issues, because as we recall, one of the comments that you had was that the public interest grounds that the Commission should consider should not be restricted to the 4 public interest grounds that are listed in Section 12A3, but you were of the view that the Commission should have a more expansive interpretation into considering constitutional rights, for example. And I think we're very happy that you're here so that we can also engage on that issue, because one of the things that we've noticed on some of the other comments were that, and I think Lane took the audience through that, where that the Commission should not go beyond the limits of the Act. So not that there is a contradiction, because every legislation should be interpreted in accordance with the Constitution. But it's interesting to have a little bit that balance. So if you can clarify on that point, it would be really good.
Would you like me to clarify now?
Yes. That would be.
So Section 27 has taken a sort of a three-pronged approach when commenting on these guidelines. And first we've looked at one specific factor in the public interest provision, that being a particular industrial sector or region. And we've cited a tribunal judgment, the Independent Industrial Development Corporation and Anglo-American, which states that this particular factor opens up a whole range of issues. So that's one way to view how we've interpreted an expansive approach. The other approach which we've taken is to state that the factors listed in the public interest provisions is a non-exhaustive list. And when assessing markets in which the goods or services traded are constitutionally entrenched rights, that the socio-economic right contained in the Bill of Rights applicable to that particular sector should be taken into account. And then the third approach would be that provision, the public interest provision in its entirety, should be interpreted in light of the preamble of the Act, the Competition Act, and therefore the Constitution. Does that give you enough clarity?
So I guess
the debate that I wanted to trigger a little bit also from the audience is that there's been comments that in fact it could go beyond what the Act requires the Commission to look at. So it's that balancing of being restrictive, of looking only at those four public interest grounds, but also the expansive by looking at the right to education. For example, one of the interesting cases that was mentioned was on education. So it's that now the Commission finding itself that there is this view that the Commission should actually only be looking at those specific grounds, but also a very interesting view coming from Section 27 that it can be more expansive. But we can also have, I don't know if any other comments from the audience.
Doesn't one have to be careful in this regard to lose the certainty that merging parties need? And also, I think one of the submissions talked about the ICN guidelines, and you ought to be following those. Doesn't this start getting a bit murky, and merging parties won't be sure where they stand, where the boundaries will lie, and doesn't that become rather dangerous? And I understand you saying you're concerned that it might go beyond your remit. I think that might be precisely the concern that might arise. Although I appreciate that the Constitution binds us all. I do think it might bring you into some difficulties.
Just in response to the debate that's been sparked, the question that's been put to Council for clarification certainly goes from trying to balance the factors that need to be taken into account in the public interest relating to a specific industrial sector. This is the second part of the analysis when you come from a competition assessment. Obviously, it would be in the public interest from a constitutionally entrenched right perspective that the competition and prices and choices within that market are protected through the first element of that merger assessment being protecting competition in that market. If competition in that market is protected, we can certainly see a protection of constitutional rights through provision of services and products based on the Bill of Rights through competitive pricing and giving customers choices. If it comes out that it is a negative effect that then needs to be balanced, or a positive effect needs to be balanced with a negative public interest effect, with the factors that the Commission is taking into account, we're seeking clarity from councils whether we actually need to, based on Leslie's comments, to form a separate factor analysis or a separate analysis or further analysis on a separate constitutionally entrenched right
other than what we've already placed in the guideline to say whether the merger impedes a certain public policy goal. What is the nature of the product in that sector? What is the importance of that product in that sector to the economy? You know, can that constitutional analysis be subsumed into those factors already? And would it give sufficient protection to that right through the analysis, and also giving the merging parties clarity and certainty that only these factors will be taken into account, and not a completely separate and possibly over-expansive analysis on a constitutional right as a separate analysis, as a separate factor? Can that analysis or protection of constitutional rights and products be already included in the factors in the guidelines, as well as the competition assessment as well?
Thanks for that clarification. Okay, so you mentioned the public policy goal aspect within the guidelines, and you've stated that an analysis of socioeconomic rights relevant to a particular market can be subsumed within an analysis taking into account other factors. So what if the guidelines had to expressly mention the Constitution as opposed to public policy goal? And have public policy goals subsumed under the term Constitution, would that not fit within what you've stated?
That is essentially what we're asking Council for, because balancing the interests of the merging parties as well, we will need to get clarity on what that analysis would have to be. So if we leave it as such, would it give sufficient protection to your concern and give the merging parties sufficient clarity on what that public policy would be, or the strategic nature of the product to the sector, etc., etc.? Or are we obliged to have a separate factor that we need to expressly reference constitutionally entrenched rights?
Any other comments or issue from the audience? Maybe on the onus, the issue on the onus or the shifting of the, because I looked like the public comments, it was one of the issues that was fairly controversial. But Sim might try to clarify that, but if there are any comments on that specific point, or any other issue that maybe members of the audience would like to have clarity on, would like to have a discussion on.
Thanks. I'm not sure if where we stand to have a discussion, but obviously employment is a big issue whenever we're doing filings. So where we stand at the moment, as I understand you, well, I don't know. One of these concerns is how far back we're having to go to and justify retrenchments prior to a merger. Not sure where you're standing on that at the moment. Maybe I've missed it. It's a bit funny.
Okay, I'll try and answer that, Leslie. So I'm not sure if I've understood clearly the question, but I think if you're referring to the pre-merger retrenchments, and that the requirement that parties inform the Commission when they make a filing on what retrenchments have taken place, I think that is just it's a requirement we've put into the guideline. It's not something that we can force parties to comply with, because it's not there in the Act, it's not in the rules as well. So it's something that the parties will have a discretion, I think, to apply or not. But I think the purpose of having it in the guideline is that we know from experience there's a lot of delays in the investigation when there are retrenchments taking place at the same time as the merger investigation or prior to the merger merger being filed with the Commission, and the Commission is unaware of this, and then it's brought to the Commission's attention either through the unions, through employees, or some other entity, and the Commission has then to investigate whether that is merger specific or not, and it has taken a lot of time, and it often delays the investigation. So I think in most cases where we've done that kind of investigation, it's because it hasn't been disclosed upfront. And so the idea of having that kind of provision in the guideline is to ensure that there's cooperation and that there isn't, insufficient information, there isn't the delay in an investigation, such that, halfway through the investigation, the Commission is stuck with investigating whether retrenchments that have just come to its knowledge is merger specific or not. And I think also the Bidvest ad hoc Ingle merger that was approved last year at the tribunal has hinted at that kind of requirement.
Just, if I may, just quickly carrying on that, I think Lane put up the issues around the Labour Relations Act and the Competition Act tension. I'm not sure if that's something that you've resolved or that you're taking to council, or where we're going to stand on that one.
That's one of the issues we've taken to council, because we do realize that there may be a difficulty in implementing that kind of provision. So that's one of the areas where we're seeking clarity.
Just to,
My colleague who dealt with the Bidvest merger wanted to give some clarity on the issue you raised.
Now, all I wanted to say to my colleagues was that there's still a lot of internal debate on those issues, so the Commission hasn't formulated the stance.
Okay. I don't know if there are any other. I saw a hand over there. No, maybe. Or am I pushy for some comments?
Hi, I'm Sandhya from Bowman Gilfillan. I just wanted to know what the Commission's stance is on the reverse onus for merger specificity for retrenchments.
Can you maybe just explain what you mean by reverse onus?
Well, I think it was a Bucketful case that said that the Commission has the onus to prove that the retrenchments are merger related. But the guidelines seem to say that the onus is actually on the merging parties to prove that it's not merger related.
There was a strong concern coming from the comments on this reverse onus anomaly, and there's a lot of internal debate at the Commission as well of whether we've used the word onus correctly, or whether it's a shifting of an evidentiary burden towards to the merging parties, where the onus is still on the Commission, but the evidentiary burden shifts to the merging parties when we put forward a sufficient case. Just to go one step back, the Walmart decision certainly formed the basis of this factor, where the court said that where retrenchments are sufficiently close to a proposed merger, it would create the impression that it is related to that merger and then merger specific. Similarly with the Bidvest decision, it certainly gave us the impression that even though it is a policy or an intention to retrench as a result of the merger after the implementation of the merger, that would certainly create this shifting of the evidentiary burden to the merging parties to say, based on what Walmart is saying, based on what Bidvest is saying, is that the retrenchments that we now need to know about, this is essentially the information request that we're looking for, is that we would need to be informed of these retrenchments, and if they are of their own sufficiently close to the proposed merger, we would require the merging parties to show or at least submit information for us to come to a conclusion or determine whether those retrenchments are or are not specific to that merger.
All right. Do we have any other comments, President?
Just going back to the requirement to keep one informed regarding post-merger retrenchments. Does one really need that? This is quite an onerous burden on the merging parties, and particularly we've noticed that it's expanded not only to the merging parties, but now also to perhaps other contracts that relate to the one of the parties to the merger, for example. That's a pretty heavy burden to place on the parties. Would one not expect that if something were happening that employees were unhappy with, they would come and tell you very quickly anyway? And also very often, it's quite a heavy burden also to have to justify that they're not merger specific if they were, if they did take place. And again, the employees, I think, comes forward very quickly to say they are merger specific in any event. But it's not necessarily so that they are. Often for operational reasons.
Thabo Khumalo from the Commission. I think the nature of this discussion for practitioners and merging parties, what they should take from this is that the Commission is constrained from an information point of view, and the merging parties are the ones that are in possession and control of this information. So as Leslie says, the employees will come running to the Commission and say these retrenchments are measure specific, whether it's pre or post. I think what we are trying to get to ultimately is a situation where we create a culture of disclosure, from the merging parties and their practitioners. We have raised this issue previously, that we acknowledge that having to create documents and bring them to the Commission is quite onerous, but I think it's in the best interest of all involved, and maybe it should be clearly articulated in the guidelines that we're trying to bring about a culture of transparency and full disclosure. I think it's in the best interest of even the merging parties who are, for whom time is of the essence, that the transaction goes through with as little hitch as possible. So I think it should come out clearly that the culture of disclosure and transparency, should be created, because the Commission is not going to manufacture evidence of measure specificity where it doesn't exist. So the merging parties control the information, and they should try and disclose much of that information as possible.
I can just respond briefly to that. Again, that requirement is not part of the Act, neither is it in the rules. So we can understand where parties are not required to comply with it if it's in the guideline. And that is also one of the issues we are seeking clarity on from Council. But just to add that that kind of a provision in the guideline is motivated by all the investigations we've done in that area, because often you would find a merger is approved and then and it's approved with all conditions, and then you get a complaint from employees or from the unions that there were post-merger retrenchments that seem to be merger specific. And so the commission then has to investigate after the merger has been approved whether those are indeed merger specific or not, and then also look at what kind of remedy it can impose, or if it can even do that. So I think that's where that kind of a provision is coming from, and we've certainly done many of those investigations. The other thing is, employees and trade unions will approach the commission where there are conditions imposed. So, for example, if you've imposed a condition such as a moratorium for a 2-year period, and there is retrenchments that happen as a result of the merger, or even not as a result of the merger, employees and trade unions have that, they are aware of the condition, they have that right to approach the commission to investigate an apparent breach of the condition. But where there isn't a condition, it's extremely difficult then to expect employees or even the trade unions to approach the commission with retrenchment concerns. The other issue around that is that we know that in certain cases where there's a transfer of a business as a going concern in terms of Section 197, and the acquiring firm would keep employees for a year and thereafter retrench employees, because from our understanding, the Labour Relations Act allows or gives a comfort period for a guarantee for a year that employees will be kept with the new acquiring entity, and thereafter they are free to retrench employees, and the Commission has no recourse on that.
Just following from the comments of what Thabo actually said, is that Seema's right. The obligation, or the seemingly onerous obligation on emerging parties to give information on contemplated retrenchments happening after the implementation of the merger, as well as trying to justify whether it is or isn't merger specific, is actually, it may be a shifting of an evidentiary burden, but it may be quite light in certain cases, where as long as the Commission is informed and has taken a view and has proceeded to say that it is not merger specific, may actually be in the merging party's best interest. If, following the implementation of the merger, a third party does actually raise the concern that these now contemplated or retrenchments that are now being implemented are merger specific. If the merging parties had gone according to the rules and said this is not merger specific and therefore I'm not informing the Commission of these retrenchments, they will then need to place information and justify that decision before the tribunal by saying that these are not merger specific. If they find it necessary that they are contemplating it, it is likely after the implementation of the merger, but that it is easily explained that it is not merger specific, and this is provided to the Commission during the filing and investigation process, it would certainly stand the merging parties in a better position when a third party then says, but aren't these retrenchments merger specific? The merging parties are then hauled before the tribunal, but then have the comfort of the support of the Commission to say, in our report, we did consider this, it was brought to our attention, and we determined that it wasn't, these contemplated retrenchments were not merger specific. The information required for this would be at the discretion of the merging parties. If they feel that unions are likely to raise this after the merger, they may feel that more information is required. However, if they don't feel that it can be easily explained through information that it is not merger specific, then it can be provided to this, these submissions can be provided to the Commission to say, we believe that these contemplated mergers after the, retrenchments after the merger are not merger specific, and these are the reasons why. As long as the Commission has this information to make this determination, will certainly assist the Commission in its determination of post-merger retrenchments.
So maybe just to add there, the Seema and Lane did allude to the fact that there are no rules forcing people to bring this information forward. But I think also the merging parties and the practitioners should bear in mind that whenever an investigation, a valid investigation is before the commission, Section 49A of the Act is very broad in what it allows the commission to do. So while it may be, the merging parties is called to decide whether they're going to give information willingly to the commission before, carrying out post-merger retrenchments, which they have deemed not to be measure specific. When the employees come to the commission and bring a complaint, and we open an investigation into that matter, it is going to cause a lot of pain to the merging parties, and unfortunately the very thing they were trying to avoid, with the onerous request from the commission is likely to follow when we seek any information which may have a bearing on that investigation. So again, we wish to reiterate that it is in the best interest of the merging parties to disclose, even when they think the information, the proposed contemplated retrenchments are not measure specific.
I think the point that we're getting from the debate around the specific question
is the fact that at the end of the day, what the guidelines are trying to seek is a situation where there can be a proper assessment on the public interest grounds, and on this specific issue, information is required. Like, for example, my colleague would probably intervene on the Bidvest one. At the end of the day, one of the remarks that was made by the tribunal was that information should have been provided to the commission and the employees in order to make a proper assessment. Of course, it was not necessarily on the merger specificity, but what we get on the side of the commission in answering those questions around the possible heavy burden on the merging parties is that it's in the best interest of the merging parties. The commission does have powers as well to request the information through summons in an investigation, but at the end of the day, it's not a situation where, like some of the comments were, that it's as if the commission is trying to prohibit mergers instead of assessing. It's a situation where the commission is trying to have information in order to assess the grounds, the public interest grounds, in terms, of course, of the law, of the legislation within the confine of the law, but also the case law. Unless there is more. No? There was a hand also.
Hi there. Excuse me. I'm Rona Ganbari from Section 27. So this is just going back to something that you had mentioned about remedies. So I understand that you're still trying to tease out what the Commission's obligations are in terms of protecting rights, and that there's still some concern about the uncertainty in terms of what factors are going to be considered and if a merger would be prohibited. But in terms of mergers moving forward, I'm wondering if the Commission has put any thought into innovative remedies that might come into effect in the event that there is some sort of negative public interest impact. So actually in our submission we cited a case, Nacional Pairs. It's an education-related case. And the tribunal in this case required that the newly formed firm had to identify and participate in joint programs with the Department of Education aimed at building capacity in public education. So I'm wondering if the Commission has put any thought into whether those types of remedies are going to be a priority or going to be available, and what those might look like in terms of protecting rights in cases where mergers do go forward, but there might still be a negative impact.
I think as far as remedies go, again, the Commission can only intervene and impose a remedy where it finds that there's a substantial negative effect and the Commission has definitely imposed remedies or recommended the imposition of remedies to the Competition Tribunal as well on public interest grounds. So we might not have been as inventive as that, but we have imposed remedies in relation to investment, for example, employment, and I think even continuing research and development, for example, to institutions and things like that. So I think it's an area where we're still considering it, but obviously, again, it's limited in terms of the effect and whether it's merger specific or not.
Just to add on to what Sima said, I also think from the Commission side, there's no free ride in terms of what remedies we can impose. Whenever we impose those remedies, they have to be addressing a particular concern that the Commission may have. So any remedy that you impose has to be tied into what the concern is.
Sorry. Yeah, no, that's very true. I'm just wondering if the Commission is, sort of going to be investigating into this to see if there are sort of creative remedies where the merger can still happen and the companies are still able to move forward, but at the same time, if there are negative impacts on a constitutionally entrenched right, there's some way of remedying it other than a financial obligation or something, just some way of having the company be involved in promoting a positive effect on that same right.
Just to clarify your question, is that your question is whether the Commission has thought about remedies in this process of guidelines, and that whether those remedies are in somehow breach of constitutional rights, whether the Commission is mindful of that. It's just a clarity on the guidelines right now. The general approach do consider that there could be remedy. I think that's what Sima has mentioned. But the second leg of your question is whether, if those remedies whether those remedies should be mindful of the constitutional rights or any interest.
Yes, precisely. So I understand that you're still trying to figure everything out, and it's in a stage where it's not completed yet. But just to ask if that's something that the Competition Commission has been keeping in mind. So in terms of remedies, will constitutionally entrenched rights in the Constitution be brought into coming up with maybe creative ways to protect that right and also protect, the companies that are merging and their interests as well?
Yeah. I think on the issue of constitutional rights, as we mentioned earlier, we're still trying to have clarity, of course, from our council, but we are mindful that any legislation and guidelines should be in line with the Constitution. So this is one of the proposals that can be taken on board and be definitely considered.
Generally, when a merger is found to not significantly lessen competition, so from the competition side, it is not a problem from the Commission, and however, it does result, or the Commission finds that it results in a substantial and merger-specific negative public interest effect. The general approach is not to prohibit the merger straight away, but to find remedies that address that negative effect. So as a point of departure, the Commission is loath to actually prohibit a merger straight off the bat based on negative public interest effects. We will certainly take into account what that effect is, and then with the merging parties or on its own, try and create or find remedies that are appropriate to address that negative effect.
All right, I don't know if there are any other issues or comments issues that we would like to discuss. we're really welcoming input and issues on this public interest guideline. So we're really happy that there is this interactive debate, and when answers are coming from the panel or from the floor, it's not to be defensive, it's just in order to have clarity and in order, as we mentioned earlier, to come up with a product that will enable both our external stakeholders and the Commission to have a proper assessment of public interest grounds. Yeah, Paul?
Apologies if this has already been addressed. I just had to go to the tribunal quickly. So we noted that in the draft guidelines, you gave a lot of attention to the first four factors that are mentioned in the Act, i.e. employment, SMMEs, abilities of national industries, and so on and so forth. And the part that seems to have been underdeveloped is the one relating to export promotion. We wondered why that was the case. It doesn't seem to us. It doesn't seem to us that that factor has been given less weighting in the legislation, and accordingly, it almost seems like there's a mandate for the Commission also to give proper attention to this aspect. In the South African context, where the economy is growing and so on, it is perhaps important to recognize that national champions can play a very important role. And we were just wondering whether the Commission is going to, when you assess now the final guidelines, give more attention to that section.
We've certainly taken those comments into consideration. I think the issue with that particular aspect of the public interest was that there isn't a lot of case precedent on that. And we did try and consider, based on what we had, on the approach that we could follow. But I think, given the comments, we'll certainly consider expanding on that.
But in the meantime, Paul, I don't know if you had specific suggestions on that specific public interest ground.
No, I think in our paper we've made certain suggestions, but the point is that in the other sections you go through the analysis, of the 6 steps or however many steps, and there you basically say, well, the onus is on the merging parties, where and that is recognized, but it would be useful to have a framework to say what would the Commission regard as weighty factors. Is it just to make a claim that it will lead to more exports? So far, we've seen over the past 15 years that has really not been accepted and significant. So, but we find as practitioners that oftentimes our clients say this merger is good for exports. It is building a national champion and so on and so forth. And what would be really useful is if the Commission could give us a framework to say, based on international precedents, maybe not South African precedents, to say, well, how important is it in your analysis and so on. So again, this factor is a factor that typically you won't find the negative, i.e. there's a negative public interest effect, and therefore can it be outweighed by remedies or a positive public interest factors. It's more, there's likely to be a positive public interest factors. It is something that I think is not necessary for the promotion of South Africa as a developing economy as well.
All right, thank you. We'll take that into account then. Any other comments or points that anyone in the audience would like to raise? Yes, Takalani?
I just wanted to
ask, after you obtain council's view or opinion, are we going to get some form of feedback from the Commission to say this is our stance on the queries that have been raised today? Yes, I just wanted to ask, you did refer to that you've submitted some queries to the council on some of the queries regarding the remedies and what have you, the approach. Are we going to get, as the, what do you call, merging parties, are we going to get some form of feedback before the publication in September in terms of the council's view and the approach of the Commission?
All right, just a clarification on that is that at the end of the day, whether we receive, I mean, even if we receive council's opinion, the Commission will still have to take a decision on that. So ultimately, it's going to be the Commission's decision and position. But Sima can clarify on the process.
There wasn't, well, we didn't contemplate that we would have to actually disclose what Council's view is on the particular issues that we've raised. But obviously the intention is to take guidance on that and then rectify the guidelines in line with what Council is saying. So it's not necessarily a situation where we're going to disclose Council's opinion on the issues and then have comment on it. It's not, that's not contemplated.
Thanks for that clarification, Seema. Just further clarification, so once you've had the feedback from Council and rectified the guidelines, before September, would there be another publication of draft guidelines in light of the rectified guidelines?
Those are the areas where we're seeking clarity from Council on. So it's not that we intend publishing it again for public comment. It may just be that the stakeholders that we engage with on a regular basis, we will have to get their views on those issues that we know affect them directly, or we know that there have been issues raised around those issues. So that's the thinking at the moment.
It's early days since the public interest guidelines are not yet guidelines. They're only in draft form. But we do know that in the case of employment, you have a wide array of questions that you expect to be answered. And I think some of that's been foreshadowed in the draft interest guidelines, i.e. the employee losses even before the transaction and so on and so forth. And I think Leslie has discussed some of those. What we wanted to know is, on the industrial sector issue, that section of the guidelines and so on, are you going to expect the parties also to proactively deal with that, i.e. provide you information before the issue is even raised? Because if that's so, then that, again, places potentially a very big burden on the merging parties to sort of come and consider the effect on the particular industrial sector. And the merger filings can then be potentially quite comprehensive or very weighty, whereas I think at the moment parties don't address those issues proactively. They only start addressing them when the Commission raises the issue or there's an objecting party or an arm of government that raise these issues. So will your practice change as a result of the issuing of the guidelines in that respect?
Sorry, Paul, just before I hand over to Seema, just a point of clarification. Is that in relation to both positive public interest effects and negative interest effects, or only where it is a potential negative interest effect waiting for the Commission to come to the merging parties to say, please give us information?
Yeah, I think it's really both. Like I say, in employment, your service standard guidelines say that you've got to provide, information about employment losses unrelated to the merger and prior to the merger as well. So the question is here, should we proactively explore the effect of the merger on the industrial sector more generally than as opposed to just in the relevant markets?
The thinking of the Commission is that we would expect parties to declare upfront where there is likely to be a negative effect on a particular industrial sector or region, rather than waiting for the Commission to bring it to the attention of the parties or for a third party to raise it as an issue. We do accept, obviously, in cases where there's no effect or it's a positive effect. We don't expect that there should be an expansive view on that in the filing. Obviously, it will depend on what the competition finding is. So, for example, if there's a negative competition finding and merging parties suspect that there is going to be so, and they're going to rely on arguments on an industrial sector or region to justify that the approval of the merger, given the negative competition effect, then you would expect that there is an extensive analysis on a particular industrial sector or region, for example. But I think in any event, the Commission would expect that merging parties inform the Commission of the effect, especially if it's a negative effect on a particular industrial sector or region upfront in the merger filing. And again, it's to prevent delays in the investigation. And I think in most instances where we've investigated that, or where there's been an issue, it's only come up when third parties have raised that as an issue.
All right. So, okay, all right. That's very interesting. Every time we think that there is nothing.
Hi, I'm Betsy. I just want to ask one question. I've noticed that in the Commission's performance plan strategy document, they sort of set out the role that the Commission has to play in saving jobs within the economy and all those things. So I wanted to find out how much weight does that have when merging parties submit information that retrenchments aren't merger specific and the Commission has sort of to play this role of saving jobs. So which factor would have more weight than the other?
As previously mentioned in the submissions from the panel, the Commission is constrained to only deal with public interest issues on employment within the scope of the Act. As clearly stated in the Walmart decision, the purpose of the competition authorities is not to make the world a better place, but to make it a better place as a result of a merger, or to avoid certain negative consequences resulting from a merger. So it cannot be a general employment that, yes, it may certainly be a policy issue, which we will take into account, which is then addressed through the public interest concern relating to employment. But it cannot be a general industry-wide condition that we have to impose. We are constrained when addressing negative effects on employment to only address those effects within the scope of the Act and then address them through remedies. It cannot be a general, almost government policy or implementation of government policy on employment. It must be within our powers within the Act.
Just to expand, or maybe to address the lady's question there, the purpose of the Act, one of the purposes of the Act, the objectives that are there is the Commission has a positive obligation, to protect employment and advance if you read it in that in section 2C of the Act, the promotion of employment is intertwined with, basically promoting and advancing a social and economic welfare within the country. Now, over the last, I think, 6 or 7 years, which is something which the Commission has also taken cognizance of in its strategy, is that we are required now to have demonstrable outcomes, and this is not something that we can. This is not a responsibility that we can take lightly, and while we note that there's a concern that we may be biased, we need to give comfort as well to the world out there that the Commission will always perform its functions without fear or favor or even prejudice to anyone's rights. I think it's Section 21 or Section 20 of the Act demands that of the Commission. However, it is important to note that the overall objective of the Act is to advance employment in the context of promoting social welfare. So it is a factor that we do consider during major investigations. But I don't think we advance any group or anyone's interest above the other.
All right, so if I can summarize, in fact, on this specific point coming from my two colleagues on the panel and on the floor, and to the question that was posed as to how much weight the Commission put on the factor of job losses, considering its objectives, is that in summary, we have to be mindful of the preamble, what is required in the preamble of the Act and the objectives, but we have to be also mindful that we have to do that within the confine of the law and also the case law. And I think that's the reason why one of the comments was that at the end of the day, when your case law requires that specific merger, for its consideration, it has to be merger specific. It's that combination, if I can put it like that, that being mindful of the broader objectives of the Commission to the protection of the promotion of employment, but also within the confines of the law, that there is a clear kind of guideline that the case law has given when it comes to assessment of public interest, which still relates at the end of the day to the merger. And I guess that's the summary that I can take from my two colleagues here. I'm not too sure if there are any other comments or views from members of the Commission, those who have had experience in mergers raising public interest grounds. Maybe general comment that you would like to make, or from our dear stakeholders in general. Otherwise, I think we will close this workshop, and I would really like to thank, on behalf of the Commission, everyone for coming, for having participated as well. The comments that we had were really constructive and valuable, and the discussion at the end of the day, what we are really pleased with is that it was more of a debate and raising issues than a Q&A session. So thank you again on behalf of the Commission. I would like to ask everyone to please sign the register. I think it has been circulated at somewhere, but if you can please sign before you leave. So on behalf of my colleagues, Sima and Lane, again, thank you very much. And we'll keep you posted regarding the guidelines. Thank you. And I think we deserve, all of us deserve a round of applause. One of the comments that actually kept on recurring, which is very positive from the stakeholders, is that they really applauded the Commission for drafting this public interest guideline. So on this note, we can upload just to confirm this commandment that we've received from the public. So thank you very much.